but I'm going to focus on those that are most important to us all as family lawyers. Firstly, unmarried couples can now live together, and that means if an unmarried couple have a baby, they can register the birth of the child without risking criminal sanction. That's something that's quite a big change to the previous rules. Drinking alcohol is now permitted, not in Sharjah, but the rest of the Emirates, although you still need to have a license to purchase alcohol. Another change that will affect us when looking at financial disclosure for expat cases is that any expat can now own a business in Dubai onshore without requiring an Emirati shareholder. So you may remember previously that an Emirati needed to have a majority share of a business, and this is no longer the case. Retirement visas have also been introduced. This is something new because many of us will be aware that previously you could mainly only be in Dubai if you had a work visa or were sponsored by a working member of family. There were some exceptions, but the retirement visa is for over 55s, and there are some requirements for a level of income and savings, but this is a significant development. But the main thing I want to talk to you about is the changes of law in relation to divorce. So I practiced family law, English family law in Dubai for 9 years. And during my time there, the local law that applied prior to the changes in law last year was that if an expat couple were divorcing through the Dubai courts, largely they had to make use of the local Sharia-based laws. And there were some hindrances with those laws in that they didn't allow for division of family assets, properties, pensions, savings, investments. They didn't provide spousal maintenance for a wife. The spousal maintenance was limited to 3 months post-divorce. And there were many other restrictions. And that meant that expats were mainly seeking to try and divorce in their home countries or the home country of their spouse. There has always been the ability to apply foreign law in the UAE courts, but previously that's been quite restricted. The foreign law that you could use to apply was the law of the paying party's home country, but there were some restrictions in that if that law couldn't be determined, it was too complex or too weighty to be translated into Arabic, then the judge had discretion not to apply foreign law. Also, if the paying party was a dual national and they had 2 passports, for example, and that foreign law couldn't be ascertained, there was also discretion not to apply foreign law. So in my experience, foreign law was very rarely applied through the Dubai courts unless the parties were in agreement and they wanted to both put forward the foreign law and have it applied. The current system is much different. The current system allows foreign law to be applied by Muslim families. The law that will now apply is the law of the place in which the parties were married. So for an English couple living in Dubai who are married in England, they can seek to apply English law to their divorce. And as you can appreciate, this has wide-ranging implications. They will need to provide translated copies of the statutory material, the Matrimonial Causes Act. And it's unlikely that the Dubai courts will apply case law provisions. But still, the ability to apply the Matrimonial Causes Act will mean that the Dubai courts can start dividing matrimonial assets and perhaps not, obviously not English pensions, but other savings and investments and things like that. It also means that spousal maintenance can be paid for a longer term. So these are really exciting developments, and they will really help expats who maybe have more tenuous jurisdiction links to their home countries and will find it difficult divorcing from the home countries. It will also be hugely useful where you have a couple where one party is unlikely to disclose unlikely to cooperate with English proceedings. I'm sure we've all had cases where we've struggled to enforce that foreign order in Dubai. Well, this will allow Dubai orders to be made. And with Dubai-based orders, the Dubai courts are very hot on enforcement. They're also very hot on uncovering assets. So on application, an individual can ask the Dubai courts to make a search at the Lands Department to determine what properties does my husband have in Dubai? What bank accounts does he have with which banks? All these things are brilliant, are going to be brilliant for obtaining the much needed disclosure we often need in these expat cases. So my understanding, I've spoken to Dr. El Hayes, who is a close former colleague of mine in Dubai, who has been practicing in the Dubai courts. He says there's been really positive developments with the use of these new laws in Dubai, and they are becoming popular for the expat communities to use. And so we look forward with eager interest to see how these cases develop, and whether we still have the run for Part 3 claims following Dubai applications, or whether Dubai does a great job and we start being able to get cases where enforcement is successful. So good, positive news is my view.
Well, and really positive news for family lawyers in the Seychelles and Mauritius, who suddenly become in demand in the UAE for all of those people getting married. Thank you for that, Alexandra. One of the law changes that you referred to in the UAE was the introduction of the retirement visa. And I know about this because I wrote an article for Family Law Week last summer entitled "Why an English Expatriate Cannot Become Domiciled in the UAE," 2 weeks before that law change. So at least I got to be right for a couple of weeks, I guess. But Andrzej and Alexandra, is it now possible then, contrary to my article, for English expatriates to assert UAE domicile? And what is the relevance of that, especially post-Brexit?
Okay, Byron. Yes. So, I mean, it's quite a significant change. It's probably useful just to give it a bit of context in the sense of what the English law of domicile is. So, the position, as Alexandra just explained, as I understood it, was that prior to last year, most people who are expatriates in Dubai were there on a work-related visa, and unless they were in a fairly exceptional and very limited category of individuals, that would end when they turned 60. So therefore, in practice, it was very difficult for anyone to obtain permanent rights of residence beyond the age of 60, other than a very, very limited category of individuals. So the legal consequences of that were as follows, because in English law, to acquire a domicile of choice, in other words, to change your domicile from, for example, English to that of another jurisdiction such as the UAE, you would have to show that you had an intention to make that jurisdiction your home permanently or indefinitely. And so therefore, as a matter of fact, it was very difficult to show that somebody could have that intention when it was in essence effectively impossible for them to remain in that country beyond their working age and beyond the age of 60. And so although that question I don't think had ever been conclusively resolved, as in your article that you wrote last year, Byron, you were fairly clear that in most cases it would be very difficult to show that somebody could have that permanent intention when it was impossible. Now, there was always a little bit of a room for wriggle in it, because there is a case that was decided in the House of Lords back in 2005, the case of Mark and Mark, which concerned a Nigerian couple who came to England. The wife was here purely on the basis of a dependence visa based on her husband's work visa. And when that lapsed and then the parties divorced, she was an overstayer. She was in England illegally, not just illegally in the sense that it was unlawful from an immigration perspective, but under English law, it was a criminal offence to still be there as an overstayer. So the issue was whether she could, as she tried to assert, claim habitual residence and, importantly, domicile of choice in England at a time when she was here illegally, criminally illegally. And the decision that the House of Lords took was, yes, she could assert domicile because she had scope to apply to regularise her immigration status in England, and therefore could potentially stay permanently, notwithstanding that she was illegally present at the time. And Baroness Hell gave the leading judgment that said that it had always been the case that somebody who was on some sort of temporary immigration status was able to potentially extend that into the future by going through the correct processes, and therefore they could have that requisite intention of making England their permanent home, even though there were doubts as to whether it could ultimately happen. So the key takeaway from Mark, however, is that it still goes down to intention. Did you have the intention when you asserted domicile of choice changing to make England your permanent home? And so that, I don't think, changed the position in Dubai when we had the old system of visas related to work. But now that you can extend that into retirement, as I understand it, beyond the financial thresholds, the thresholds are really quite low. And you and Alexandra may have something to say about how easy in practice these visas are being given out at the moment. But it's certainly now possible for somebody to go to Dubai on initially a work visa and say, well, my intention is, even when I finish at 60 working, to extend that by way of a retirement visa and therefore to remain here forever. So therefore, if the facts make it out, and it's important to stress, it goes to proving that intention, there is no longer that impossibility or impracticability bar to showing that you had that intention to make it your permanent home. So yeah, there's been a significant change.
That mark principle is helpful, isn't it? Because even if you had a case where there is relatively low assets, it doesn't matter that they don't immediately meet the financial requirements of the visa, because you can just simply say, well, it's my intention to. That might be an impediment, but it's not an impossible impediment, and therefore it's my intention to have those assets when I retire.
Yeah, and it'll depend on the fact. I mean, the thresholds are relatively low, aren't they? It's an income, pension income of
20,000 dirhams a month.
Yeah, 20,000, which is about £3,000 or £4,000, isn't it? So it's not a large pension that's required, and the asset threshold is $500,000, I think. So it's, again, not so high. But again, it's going to be fact dependent, isn't it? If you've got somebody who's already 58 or 59 and they've got virtually no pension and they've got virtually no assets, it's clearly going to be difficult for them to obtain a retirement visa at 60, given the limited time frame they've got. But I agree, Byron, if you're in your 30s or 40s with plenty of time to reach that position, you're going to be able to show it's realistic that you're intending to meet that threshold and therefore to remain there permanently.
But surely Andrzej's point is absolutely right. It doesn't change English law at all, and therefore doesn't change the fact-specific threshold from an English law point of view to demonstrate that you have indeed abandoned your previous domicile and adopted for an indefinite period into the future your new domicile, in this case wherever, UAE.
Well, we know your domicile of origin is sticky, don't we? And so, and that is hard to come unstuck from, as we know. But one of the things that we've certainly found is that post-Brexit, sole domicile is now very powerful. You know, you need residence plus intention. Intention is very hard to disprove in the end, really, as long as there are some things that link them clearly to the jurisdiction. How do you disprove an intention, really?
Yeah.
And also, how many people want to spend tens of thousands of pounds on a jurisdiction dispute to find out whether that intention is genuine? So
well, you're right,
sole domicile doesn't get contested.
Yeah, I mean, you're right, Byron, but for Brexit, this change would have been much more significant. But now, because Brexit means the maintenance regulation has gone, and therefore there isn't really any distinction between sole domicile and joint domicile for the purpose of the court's powers, either on divorce or under Part 3. It does mean, quite helpfully, that it doesn't really make very much difference to the position, because even if one party, often the husband who's there on the work visa, shows that I intended to be here now permanently, or even into retirement, it's quite difficult to show that the other spouse has got the same intention, and certainly one spouse may well be able to show that they've retained their domicile in England.
Well, I don't think anybody misses the maintenance regulations, so good riddance from me. Anyway, so there are undoubtedly particular challenges facing proposed parties that are based in the UAE to issuing proceedings in England for divorce and financial orders, and also financial orders after a foreign divorce under Part 3. So Alexis and Tim, what are those challenges, and how do you both propose that they could be overcome by proposed parties?
Well, let me kick off, and it's really picking up on the pain that Byron feels about missing or not missing the maintenance regulation, because whatever your views of Brexit, particularly from a family law point of view, in terms of the shackles that the maintenance regulation imposed on us by reference to maintenance cases, including capitalized maintenance cases, having as a jurisdictional bar a divorce petition based on sole domicile. That has now gone, even for the largest opponents of Brexit. That must be for the real punter an advantage that jurisdiction is enlarged or re-enlarged back to where it was with sole domicile, and therefore for an expat absolutely critical that she or he is now back in the position where they can obtain full English jurisdiction even from afar, and that is absolutely critical to everyone's understanding of the new position since the critical Brexit SI, which we all need to learn the number of at least, 519 of 2019, the jurisdiction SI to deal with Brexit. But that is the one that takes off the shackles of the maintenance regulation and replaces divorce jurisdiction with sole domicile for all purposes. And of course, arguably, makes jurisdiction easier from the point of view of habitual residence in arguably confirming the Marinos definition that provided you can prove habitual residence at the last minute, it doesn't matter that you have not been habitually resident throughout the 12 months. That too is a crucial change which is likely to increase the sense of London being the divorce capital. So that seems to me to be the most exciting point, especially from the position of the returning expat, or indeed the expat who's not returning but simply staying put and starting their divorce petition. But I don't know, Alexis, whether you have other thoughts about that, particularly speaking against the proposition that SI 519 of 2019 opens up habitual residence by confirming Marinos.
I mean, I'm afraid I'm with you on this, Tim, although reluctantly so, I must say. I think you're right. I think it's absolutely likely that we're going to get a lot more expats coming to England on the promise of a holiday, but actually staying, bringing with them their furniture or sending their furniture secretly over, booking school applications secretly, and then saying, actually, this was never a holiday. My intention was to be here and settle and therefore achieve the habitual residence. So I think we're going to have a lot more skullduggery, certainly in the English courts. But I couldn't agree any more strongly with you, Tim. There are going to be a lot more cases in England because of this vast opening up of domicile. I'm sad about it, I must say. I think the habitual residence, my own personal view, under the previous approach, that there was the need for habitual, that word was there for a reason. And I'm sorry that we're probably losing that, and the emphasis is going to be a growth in divorce law. I don't think it looks great for England, I must say.
It is worth saying that there are some serious players who disagree with the proposition that the SI that I've mentioned, 519 in 2019, they disagree that that SI has the effect of confirming Marinos and rejecting Philip Moore's judgment in Peerberg. And the argument goes, the only purpose of the SI was to deal with the third possibility raised in Choi and Tan, and that therefore the SI itself, so the argument goes, doesn't really change anything. But it seems to me, I have to say, if you read the words on the tin and inside the tin of SI 519 of 2019, it's pretty clear that Marinos has won and Peerberg has been consigned to wherever it should go.
But we're yet to see from any of the senior courts beyond High Court level interpretation, so it would be useful to see. I expect we will, because we're going to have a lot more financial remedy cases in this country directly under the divorce jurisdiction. But of course, there's also going to be a massive knock-on effect for Part 3 claims, because the same provision applies now under Part 3. And you'll all be familiar with the Part 3 procedure where there is a connection with this country and a foreign divorce. The court here can give relief after a foreign divorce. And now the changes, now that we've lost after Brexit, the maintenance regulation, the new approach, same sole domicile or habitual residence for 1 year. So we're going to have a massive influx again of cases where there has been a foreign divorce, but the applicant or the claimant wants to come and try and get provision in the United Kingdom or England and Wales on the basis, and of course we've got to be clear about this, that the domestic, and in this case the UAE courts, are not going to give adequate or sufficient relief. That's a big if these days, because as Alexandra described, there is at the moment an opportunity for the courts in the UAE to employ the English approach in their own decisions, and it may now be more difficult, if that does happen, for applicants in England to say that there isn't adequate provision by way of the foreign divorce. And Alexandra, I don't know if we've had any experience of there being contested proceedings that have been successful. That's obviously what is going to be key for us to be able to ascertain whether there is adequate or sufficient relief in the UAE.
I haven't seen that yet, but I'm eagerly in touch with several lawyers, advocates in the UAE to keep me posted of these cases, not just with Brits, but with other European nationalities, to see how assets are being divided, how these laws are really being implemented.
And obviously there is another complication because of the changes in the law you have, where there is now the capacity to elect the law of the marriage. That also opens up for us the interesting promise of cases coming where the argument is that because of this new election in the UAE, you might find somebody saying, my partner, my husband is going to elect Sharia law, therefore it's obvious I will not get adequate relief. And so that may support an argument under Part 3 without actually getting a formal order in the UAE. There's a big note of caution about that because, of course, any Part 3 orders that you get in England need to be enforced most often abroad. And if you have assets in the UAE, you'll want to enforce your Part 3 order in the UAE. And we all know that the UAE is unlikely, very unlikely, will not enforce an order if there has already been a UAE judgment. So if you go down the route of getting a UAE financial award that isn't adequate, you go and get a Part 3 application in England and then try and force it in the UAE, you're going to be stuck. So I think there is going to be a period of hiatus where we're going to have to consider, are you likely to get a bad award in the UAE, which means you won't be able to enforce a Part 3 application that follows? Or might you be better not to get a UAE order, go straight to the Part 3, or alternatively arbitration and post-nuptial agreements, which I hope we're going to talk about shortly, because I think that's the key for this jurisdiction. But if you're not going to get, if you don't want to be disadvantaged by an order that is difficult for you, you might be better just to go straight for the Part 3. So I think it's really difficult time at the moment, and we're going to have to see how the jurisdiction in the UAE operates with this new capacity to elect the law of the marriage.
On the flip side,
I'm so sorry, Tim. The only other problem I was going to say is that you're not just asking for an opinion on what the UAE court would do. You're also potentially asking for what is the law in the Seychelles, how does the UAE interpret the law in the Seychelles, and who is going to provide you with that expert opinion?
And what if, for instance, the couple married in Las Vegas, where you might have a very generous provision? How are you on earth going to argue in an English court that that wouldn't be adequate? It's going to be complicated.
I'm sorry, Tim, I spoke over you.
No, it was just the flip side of Alexis's point, which she mentioned in relation to English jurisdiction for Part 3. It is worth emphasising that it really is still the 12 months of habitual residence and that means 12 months, not at the last moment. So there is a distinction now between post-Brexit English divorce jurisdiction and Part 3 jurisdiction relative to habitual residence.
That's right. So the Marinos and Monroe dispute doesn't pay any interest in the Part 3 applications. It's now straightforward domicile or habitual residence for a year. And don't forget the matrimonial home concept. If you have a matrimonial home in England, you can apply under Part 3, but of course the relief is very much narrower, particularly when it comes to interim relief.
Alexis mentioned there about enforcement. Duncan, hello, we haven't heard from you yet. How do you suggest that people approach recognition and enforcement of orders in England and the UAE?
The key message always has to be whether you're divorcing in the UAE and want to enforce that order in England, or divorcing in England and want to enforce an order in the UAE, that you get advice from a local lawyer in the country where you want to enforce, because that's often the most important part of anything, making sure you don't end up with a Pyrrhic victory and a piece of paper that's of no actual value to you. So I think probably best to break it down into three things. So divorces, financial orders, and then children. In terms of divorces, the English court is quite liberal about recognising foreign divorces. I think probably from two policy perspectives. One is having people divorced for one country and not divorced for another country causes various difficulties. And I think the English courts want people to have an element of certainty and understand if they're divorced, they are truly divorced. But secondly, because we have the fallback of, first of all, a generous jurisdictional regime in England, but also the Part 3 safety net, perhaps the consequences of a divorce in a different jurisdiction aren't as difficult for a party as they would be if you couldn't have what the English court would consider to be saving relief in England. So in terms of the law, well, Section 46 of our Family Law Act 1986 will recognise divorces in a foreign country if they were in proceedings. So here, if they were effective for the UAE law and either party is habitually resident or domiciled or a national of the UAE, then a proceedings divorce from the UAE will be recognised in England and the parties will be divorced. That obviously means they can't then get re-divorced in England. And the relevance of that is English financial claims stem from the divorce itself, usually, apart from the Part 3 exception we've heard about. If you have a non-proceedings divorce, so maybe a talaq outside of proceedings, then it can be effective if each party was domiciled in the UAE and either one was domiciled and neither was habitually resident in the UK for a whole year immediately preceding commencement of divorce proceedings. So again, it's not just proceedings divorces, but those done differently too. There is an exception, though, in that the court can refuse to recognise divorces in limited circumstances, and it's been interpreted in a very restrictive way. So, for example, if no notice was given to one of the parties that there was going to be a divorce, or if the divorce was manifestly contrary to public policy. And a recent example we've had in England is a case called J&J of Mr. Justice Peel, where the husband had evaded service of the wife's divorce proceedings in England, and the English court, because of its own failings, had failed to act on her application to progress her English divorce, and the husband had managed to secure a divorce in China. And Mr. Justice Peel said, well, I am going to recognise the Chinese divorce, but don't worry, there is still Part 3, which is a bit of a saving grace. And Andrzej, I don't know if you had anything that you wanted to mention in relation to this particular issue.
Well, I think it's probably just worth highlighting the case of Lachaud and Lachaud, which is a case specifically in relation to Dubai, where Mr. Justice Mostyn recognised a divorce that was granted by the court in Dubai, and the Court of Appeal agreed that he was right to do so. And the Section 51 defence that you referred to, which the wife tried to run in that case, both on the basis of not being able to participate in the proceedings and also on public policy grounds, was rejected on both grounds. So yeah, as a matter of normal standing, if the process in Dubai is followed, the English court will probably recognise it.
I think what Mr. Justice Mostyn said is that, having looked it up on Google, because I don't think there was any expert evidence in that case, he thought that the UAE divorce process was pretty much the same as the English one.
Yeah, especially the Court of Appeal agreed with his conclusion, but not by the method by which he reached it. I think there was some criticism of his method.
And it's worth saying the French court reached the opposite conclusion.
Correct.
But nevertheless, for
On
English
Protestant
purposes,
grounds,
absolutely, it's a really interesting case.
Yes, exactly. Well,
Picks up, if I can just say, Duncan mentioned Mr. Justice Peel's recent case, and there are some interesting quotes in that case of J&J, where Peel J quotes from El Fadl and quotes from Ola Fisoy, and the particular point is judicial outcomes in one country can be relied upon in all others, provided there was, as here, a proper connection with the first country. That's Holman in Ola Fisoy. And what Lord Hughes, as he then was Mr. Justice Hughes, said in El Fadl, one country should accept the conscientiously held but very different standards of another where they are applied to those domiciled within it. And so again, that is why the English discretion to refuse recognition is applied so very sparingly. Basically, if you've got a foreign divorce, it's going to be valid in England, is the short point.
it's not uncommon, though, in the UAE to have a divorce process where one party's not given a reasonable opportunity to participate, of course.
Yeah, I was just about to make that point, Byron.
That
Yeah,
could be problematic.
it's always going to be case specific, isn't it? I mean, I know because we've had a couple of examples of it, haven't we, where because the procedures in Dubai are somewhat flexible, there are cases, for example, I've had one where despite there being a hearing listed, for whatever reason, I think it was dealt with remotely. It was a case that you and I were dealt with, Byron. The wife simply wasn't admitted into the hearing, so she clearly didn't have a right to participate. But interestingly, the Dubai Court on Appeal did overturn that divorce decision. So I suppose it also raises the question as to whether you can make an application for non-recognition in England if you fail to exhaust an available appeal process in the other jurisdiction. I suspect the court will probably be reluctant to refuse to recognise if you haven't done everything you could have done in that jurisdiction.
I think that was the issue, wasn't it? Where there was, to a certain extent, lack of attendance and lack of engagement in the Chinese courts, but clearly the opportunity was there. So you can't just put your head in the sand, and that would be very dangerous.
Yeah, and it's also important to remember the cultural differences in these countries. And so in the Middle East, it's considered very much a right to get divorced. That's obviously reflected in the nature of a talaq. And the fact that the other person didn't participate isn't really that relevant, particularly when it's a husband asking for the divorce. But Alexis, you and Tim, you asked about this a moment ago. Can you help us with how agreements can limit both the scope for the arguments that we have in these type of international cases and regulate outcomes for us? Alexis. I think you're on mute, actually, Alexis. And it wouldn't be a modern day meeting, would it? Unless somebody shouted, "You're on mute." No. I think that's what's going to happen at Pantos in the future. That everyone would, in chorus, say, "You're on mute." Anyway, Alexis.
Yes, I'm so pleased to have fulfilled that job. Yes, I mean, where we have this difficulty, agreements are going to be so important, aren't they? Because if we can reach some form of agreement, principally when the parties are still talking to one another and hopefully affectionate to one another, you're likely to be able to try and track a path, possibly, for the route that you would want to take if that relationship broke down. And I'm thinking primarily about postnuptial agreements, about selecting particularly perhaps arbitrational routes, and even maybe agreeing at the outset of a relationship to elect which jurisdiction or which applicable rules you'd like to apply. So agreements are going to be really powerful. And I think what we need to grasp, certainly as advisors, is getting people, our clients, to think about that before the marriage breaks down, because obviously postnuptial is just as important. And I think if we can start to guide our clients towards thinking in a slightly more open way about how to resolve potential conflicts before they arise, it's going to be really significant and probably helpful in the outcome. So certainly that consensual path, and I think we're going to talk about that later with Duncan, but talking about enforcement, there is a problem with the enforcement of the arbitral awards, which we've got to think about. And I know Andrzej will have a significant amount of experience with this, but one of the problems in England, if you have an arbitral award, it only becomes final once it's made into a court order. And under the 2015 President's direction, we were told very clearly that it needs to be converted into a consent order to be considered final. And under the UAE, as I know Alexandra will tell us, we can't apply to have an order recognised or an award recognised here until it is final. So we are going to need to get that order made. And of course, you can only have an order made final if there are grounds for jurisdiction for the suit and the consequent financial remedy. So one finds oneself in a circle where you need the jurisdiction for the divorce and the financial remedy to be able to have an arbitral award that is enforceable in the UAE as things stand. I don't know whether any of our speakers have a view about where we are with the problems that have occurred in recent months and years with the DIAC and the DIFC. I don't know whether we've got any views about that.
My understanding is that enforcement through the DIFC is very difficult now as a result of this judicial body set up a couple of years ago. But I think with these new laws, we will see in the next year whether the application of foreign laws within enforcement proceedings will open up. Because the view of the practitioners in the UAE is that it certainly will, and enforcement using foreign laws will become the done thing.
So I mean, that would be very welcome, because I mean, I don't think it's a coincidence that Mr. Akhmedov, in that mammoth bit of litigation, one of the jurisdictions that he chose to try and park his assets in order to avoid the wife's claims was the UAE, which I suppose really underlines the fact that up until now it has been very difficult to enforce an English judgment in the UAE. There are more options perhaps to enforce a UAE judgment here, but there's very limited options going that way. So if that's a change, which we're going to see through the UAE courts, that's a very welcome one.
And Andrzej, don't you think that the idea of reciprocity is going to be significant? Because under the UAE law, they will only honour foreign orders if those foreign orders are honoured in the foreign court. And we've had, I'm sure you'll all be familiar with the 2020 case, which was a Queen's Bench Division case, Lencore Energy Trading, where the English court ruled that the Dubai judgment, that was in respect of a tripartite commercial agreement, was recognised and enforced. So from an English perspective, recognising and enforcing Dubai judgments is a really important step, because that now opens the door for the Dubai courts to show a reciprocal enforcement in your jurisdiction, and I think that's really important.
Yeah, well, let's hope so. I mean, there's clearly a lot of push in the commercial sector, isn't there, to have reciprocity. Whether that extends into divorce and family affairs remains to be seen, I suppose.
Well, it didn't help much in the Brexit argument.
So very quickly to try and tackle one of the questions that was asked, I think on the chat room, was whether or not you can enforce UAE orders in the UK. To pick up on that very briefly, there is no reciprocal treaty as we have with many countries, and so what you're relying on is the common law in England, and so you need to sue as a debt. You have to show that it's final conclusive and for a definite sum of money, and you can launch proceedings and then seek summary judgment in England. Obviously, there are various pitfalls that you can fall into, but completely this all stems from the idea of reciprocity. And as you say, Alexis, I think if there's a move in that direction both ways, then it's going to be more encouraging, and you'll probably find that there's going to be more respect paid by the English courts to UAE decisions if the UAE courts are going to be paying respect to the English ones too.
And Duncan, I would welcome a change where we see our judges in England and Wales reaching out to the judges in the UAE, because it's that personal connection and that personal interchange where a direct link encourages confidence, it encourages faith in each other's systems. And that has happened in Europe. It happens through countless decisions where judges here simply pick up the phone and ring a colleague in Spain or Sweden, and it has a real direct impact. And if we can actually see those changes on the ground, I think it's going to have a significant impact on how the law generally is perceived and enforced in our respective jurisdictions.
Such a good idea. But I think that would be very welcome. I mean, it's also worth noting that in personam enforcement in a typical everyday case, particularly those involving professionals, is actually quite powerful. because most people do not want to be in breach personally of an order with the consequences of that following. But yeah, I mean, it would be great if there was a more sort of in rem style enforcement, if I can put it that way. Moving then on to some of the more sort of procedural innovations that have happened recently. For me, the advent of remote hearings has been pretty seismic. In fact, one of the most seismic things that's happened in family law for a long time. And I'm a massive fan of it. I think it provides access to justice in a far greater way. And whilst it's not correct for every case, and I would say probably particularly public law children cases, for the vast majority of financial remedy and private law children cases, I think it works really well, especially for those based abroad. Duncan, Andrzej, am I right about that?
Yes, I mean, domestic only cases, I think the real boon for the lawyers and the parties of not having to attend court, sometimes some travel distance away, waiting all day for a judge to be available just to discuss who's going to value your home. It's far more sensible and efficient to be able to do basic procedural matters over the video link. And particularly that we had those sorts of hearings where people were criticised for not flying from Dubai or America or wherever it might be to attend a very basic procedural hearing in England. And that's now gone because we can do it remotely, and I think we will continue to do it remotely. And the remote access to justice, I mean, it's worked well from my perspective, both at settlement hearing level, FDR, but also when you're dealing with final hearings. There are some final hearings that won't be appropriate to deal with remotely. I think if you have decisions where people's children might be taken away from them, or you have issues of pure credibility, it's going to be harder to do it over a video screen. But most cases that we deal with when you're dealing with financial cases or perhaps more discrete issues about the children, rather than having everyone fly to England and attend a court, it can be dealt with well and remotely. And I'm hoping that that's an innovation that will survive when the pandemic restrictions are lifted here.
Yeah, well, I personally, I expect it to. I mean, I think there's been a cultural shift, which certainly in relation to international cases now, we're not going to go back on. I think even if we see the courts move back towards in-person hearings for domestic cases, I'd be very surprised if judges are not more willing to have remote or hybrid hearings where somebody's out of the jurisdiction, including final hearings as well. I agree there's going to be those category of cases where that may not be suitable. But the idea of making somebody fly several time zones around the world for a relatively short hearing just seems ridiculous now, doesn't it?
Andrzej, do you find, as I found in certainly the FDRs, private FDRs or court-based FDRs, the fact that the parties aren't dragged to court, sat in front of a judge, aware of the seriousness of the event, they don't always commit. They don't have the same respect for the court, the same respect for the court process, and the same comprehension of this being a significant part of the proceedings. And I've certainly had cases where parties have simply sat looking, got up, made tea, not taken it seriously. And I think there is an absence of the gravitas of court, which does have an impact on some of those settlements.
Yeah, I must say I've not had that experience at all in the ones I've done. I mean, but I can see there may be a category now where that will happen, because before the pandemic, private FDRs and all of these alternative options, they were done consensually by parties who wanted to do it as a genuine alternative to the court. And they were almost a self-selecting group of people who wanted to do it in a slightly less confrontational way. Because of the pandemic and the pressures on the courts, there are people now going into private FDRs who previously probably would never have considered it, but they're doing it because it's the only way to move the case forward, and judges are leaning on them very hard to do it that way. So maybe there's now a category of people who are just less amenable to it, and I suspect they'd probably be quite surly and difficult if they were a court as well, but they're now in a different forum.
And you're right.
There's a related consideration, Alexis, I think, for your point, which is that at least in the mediation realm, a category of party, a subset, finds it easier from a disinhibiting point of view to deal with very difficult issues on screen that they might be simply unable to deal with face to face.
I mean, yes, I agree.
And so that has, in a category of mediations, actually been a positive assistance, despite being counterintuitive for all sorts of reasons.
Yes,
it's also worth bearing in mind that as when you're thinking about alternative jurisdictions, it is considerably attractive to international people based in somewhere like the UAE that they can attend remotely. and it can all be dealt with without them having to travel. I mean, prior to lockdown, I think people sometimes forget that to attend an FDR, you need to probably take a week off work. And if you both have to attend, what happens to your children who need to go to school that week? And what happens if you don't have any family support with you in the UAE? Is everyone supposed to travel over to England for that week? And then how much does it cost to get everybody to travel over to England that week? And suddenly, when you're talking about the cost and inconvenience of a court hearing, that's now escalated dramatically just because you happen to be based abroad.
We're playing catch up, particularly when so many of our clients conduct significant business contracts and transfers and endeavours on Zoom and remotely, and have been doing so for years. We are behind the curve, but I think we are catching up.
Yeah. One of the things I found with private FDRs particularly is it's easier with this way of doing things to maintain momentum. You sometimes get to the end of the day where if you were at court, you get to 5 o'clock, literally the cleaners would be sweeping up around you, you'd be kicked out of the building, and it was quite difficult to move it forward. Whereas there isn't those limitations around it. And also, even if you don't settle on the day, it's much easier to reconvene for an hour the following day, whether it's before or after court hours or whenever, rather than trying to coordinate diaries and a building and get everybody physically in the same place, just because we're all sitting at a computer anyway, and logging in takes 2 minutes and you can have a meeting whenever.
And if it's done properly, you can share schedules, you can have clean exchange of bullet point offers, and it does avoid confusion, you avoid misunderstandings. It can be very clean if it's done properly.
There's also the potential to give people a window in the day when they're waiting for the other side to respond, when if you're stuck at court, you're having to sit in a room making small talk, and actually they can get on with something else. They can spend a bit of time doing something that they're going to enjoy rather than having to focus on the situation they find themselves in. So I think there has been, I agree, a cultural shift, and particularly people are now more willing to say, well, it's 6 o'clock, we're not quite there yet, let's pick up the reins again next week. And we used to be worried about that, didn't we, if it was a court hearing, because everyone goes away and the next time you see everyone is the final hearing. But I think people are now much better at re-engaging with each other over the next week rather than just saying they will.
I have to say I'm less optimistic about that last point, Duncan, because it seems to me that as soon as you let them off screen and they go back into their lives and all of the other cases they've got to deal with tomorrow, you've got exactly the same problem as you have in the physical court. And it's why some judges always used to say, right, lock the doors.
Yeah, I'm not so
well,
sure.
I refuse to believe that Duncan doesn't really miss the waiting rooms at the CFC and spending hours making small talk, sitting in those. Who wouldn't want to go back to that tomorrow if we could?
Have we got time to look at the extreme other end, which is the contested factual evidence?
Of course.
Case.
Well, I was about to ask you that actually, Tim. I mean, do you feel that it is, how effective is cross-examination remotely?
I have to say I think it is less effective. The balance for me is if the alternative is having no case at all, then clearly it is better to have the whole trial, including contested cross-examination on screen. But there will be a category of case where the individual case management decision is likely to remain. This needs to be an in-person hearing because the issues X, Y, and Z require absolute face-to-face cross-examination, and not, especially where you're dealing with people in difficult time zones, difficult language circumstances, and difficult bandwidth. There are bound to be cases where it must remain the right case management decision. This has got to be in person, despite the fact that, for example, Mr. Justice Francis is almost messianic now in saying that in his experience there is absolutely no case that cannot be dealt with as well on screen, and particularly his point being that it is quite a good reminder to judges that judges do not have some kind of extra psychology degree, and the emphasis that we've always put on the demeanour of the witness and the judge's assessment of the demeanour of the witness is in fact a red herring and likely to lead to false positives.
Yeah, well, I don't think he's, I have to say, I am a massive fan personally of remote hearings, and not just because it's much easier for me personally to attend them now. I do think that they're very effective. And of course, If they're not effective, then what about all of the decisions that have been made over the last 12 months with remote hearings? Are they in some way unsafe then? Because the conclusions the judge led were somehow affected by them being remotely achieved. And nevertheless, we can leave that as something for us to reflect on. Last question. For us, with expatriate law, our cases often resemble sort of law school problem questions with people coming from different places and growing up on military bases and having parents from different countries, and et cetera, et cetera. For those cases, therefore, where there's no clear link to any one country, and you have legal arguments with varying tenuous degrees of connection to a variety of possible countries, is there a possible third way of resolving those disputes? So that instead of saying, like, the chai and peng, everywhere's open and it's just a rush to a conclusion as soon as possible, is there something else, do you think, that people could try and adopt in those sorts of cases? And this is to everyone.
Like I mentioned at the start, that my own view is prenuptial or postnuptial agreements are key. And particularly when you're in a location like the UAE as an expat family, if you can elect an applicable law or elect a format, so whether it's early neutral evaluation, arbitration, or even location in the UAE courts, but if you can elect that in your prenup, postnup, even if it's just the applicable law, you're going to save yourself enormous amount of trouble further down the line, particularly when you're looking at any kind of consideration of that decision in the English court. If you end up here and you've made that election, I imagine the English courts are going to hold you to it.
But you still can't invest people with, or invest the court with jurisdiction. And that, in that respect, Byron, you may miss the maintenance regulation because, of course, that did provide for jurisdiction by agreement, and we've lost that.
I think this is.
But Tim, there is scope, isn't there, to reach a contract which you can then sue on as a commercial or civil contract. And there was the Russian case, wasn't there, a couple of years ago, the name of which eludes me just now, where after a Russian agreement was reached, the wife sued on it in the Charter Division and succeeded in obtaining a monetary judgment. So there is still that avenue. I know it's not necessarily 100% certain, but it is potentially there.
I agree, but it is a very small percentage and a very expensive route.
Well, there are also a not insignificant category of case where you have two sensible people who just want a fair outcome and will follow a fair outcome. And what they want is a process that they can adhere to. And so, and they acknowledge that an application of Sharia law, for example, wouldn't be appropriate. They acknowledge that they don't want to have an argument as to whether it should be Sweden or Spain as the jurisdiction that's applicable. What they want is just a neutral, natural justice style fair outcome. And we've certainly had cases where people have asked us whether that is possible and where we have tried to facilitate it.
I think there are two strands to pick up on there, aren't there? There are the people that want to find a fair outcome and work it out themselves without jurisdiction battles. And then there are people who are worn down by the prospect or having gone through jurisdiction battles. And so the carrot and the stick, in a way, drawing people to find another way. There is the international arbitration financial scheme, isn't there, which is out there where an arbitrator from a neutral country will be appointed to determine where you are most closely connected, and then will go on to determine what the outcome should be. I'm not sure yet what the take-up has been of that, but that's one approach. But the other, I can see entirely Alexis's point. If you elect a jurisdiction or a law, at least then, for example, you might say, well, I'm going to elect English law and I'm going to arbitrate under the IFLA rules. No reason why you couldn't arbitrate whether or not the English court's got jurisdiction to make an order backing it up. That will be the problem later on. But what you don't want is to create yet more litigation about how you're going to litigate.
A word of warning: if you're going to elect an applicable law or even a forum, get advice on it, because we've got the Avon case, Miss Justice Mostyn and Petchy, where they applied or said they were going to apply New York law. The respondent didn't have any advice about it, didn't know anything about it, didn't even read the documents as far as we know. So if you want it to stick, and you're going to get or try and impose applicable law, you'll need advice on it, and you'll need to make sure both parties understand what they're doing. So it's about the preparation if you want it to work in this country in terms of coming back to get enforcement.
And especially for stay applications, those agreements about jurisdiction are likely to be absolutely determinative. Look back at Mr. Justice Wilson as he was then in the New York case of S&S.
Yeah, so preparation is everything. If you're looking at the prenup, postnup, of course.
Absolutely. Well, look, honestly, I think we could have had this discussion over another 3 or 4 hours, to be honest. I think it's so interesting and there's so much to say. I think we're probably going to make this an annual event. And I think the one thing that I have taken from this is we're going to make it longer next year. But look, thank you all so much. It's super interesting. And it's, apart from anything else, it's so lovely to see all of you whilst I'm here in Dubai and have the chance to chat to you all about UAE and family law. But thank you all so much. And thank you for everyone who's come to attend with us.
And Byron, there have been a few questions which we haven't had time to address about UAE law.
Yes.
Please do anyone email me, and if I can't answer, I'll put you in touch with an advocate in the UAE who can. So just ping me an email if I can help with any of these practical issues. And thank you so much, everyone who's helped us today.
Pleasure.
Take care. Speak to you all soon.
Thank you.
All the best.
Have good days. Thank you.
Bye. Bye.
Bye, everybody.